Alex here with part 124 of the My Docket series on child custody and visitation. Before I go into my disclaimer, I want to let you guys know that the next video is going to be a hearing video. Keep an eye out for this because I'm actually going to set up a premiere on this video. Some of my viewers noticed that with the previous hearing video, we premiered it. It was not announced though, I just did it spontaneously. I clicked on the instant premiere button and several viewers came on, and it actually turned out to be a very fun experience. Everybody really liked it. So based on that practice run or test run, whatever you want to call it, I'm going to go ahead and do the same thing with this hearing video that's coming up. But this time I will actually schedule the premiere, and I want to let you guys know it's going to be either on Sunday or on Monday. You will notice it. It will pop up. It'll look like a live stream, I assume, but instead of saying something like, the proper person is going live, it'll probably say something like the proper person is premiering this video. I don't know what it's going to look like, but it should be similar. And I am looking forward to seeing all of you during that premiere event. It's basically it's not really a live stream. What it is it's the first run of the video, only instead of letting people watch it whenever they want to, it'll run at a specific time and it'll open a chat box. So I'll be able to chat while we watch the video. The other thing, I don't think actually there's anything else that I need to mention on that. I'm 99% sure that this is the contempt of court hearing video that's coming up. Anyway, let's go ahead and get into the disclaimer now. As with my previous videos, I'll take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. I also like to let people know that the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We are about to go into the government's response. It's been a number of videos, maybe even 10 videos since we have seen anything in the other case that I filed in front of District Judge Patrick Flanagan, that other case being the petition for writ of mandamus pursuant to the case that was named after me, Falcone v. Secretary of State. And we are about to go into the government's response. I remember reading, or not, okay, I want to go into my mindset. I remember when I saw the envelope that I had quite a bit of anxiety because I knew that this response from the government was going to control the tone of the case going forward. I knew deep down that they had nothing that they could really do with the exception of observing. Based on the Supreme Court's decision, the government didn't really have a role to play in whether or not anything that my ex was saying was true. The Supreme Court stated clearly that the government had no discretion because the legislature said so. But I still knew, with my experience in the past, that attorneys often don't follow the rules. They often don't follow the law, and they sometimes will just do whatever they feel like doing. And I had been mischaracterized over and over again, not only by my ex's attorney, but also by the government's attorney, at least, the one that was on the writ petition in the Supreme Court. His name was, I think, Charles Wayne Howell. This time, I was going to go up against I think it was a senior deputy attorney general, a Kevin Benson, who, by the way, now is a pretty big deal in Carson City. Back then, obviously, as a senior deputy attorney general, he wasn't just, sort of a newbie, but now he's definitely progressed. Anyway, I knew that this would control the tone going forward. So my mindset was very anxious because my ex was playing the long game again. It had been stated that her fictitious address was going to require proof now, and she could have either just given up and handed it over, or she could have done what she decided to do, which was to drag it out as long as she possibly could and allow it to proceed to litigation. And guys, Sam Backman talks about this. I can't remember what the title of the video is, but he says that with NPDs, and again, I'm not saying my ex is an NPD. She's either an NPD or she has severe emotional immaturity issues, one of the two. But anyway, with his characterization of NPDs, he says that they embrace dragging things out. His exact words are that the NPD will wait and see to see what waiting brings. And I almost kind of put that in his own tone. And that's kind of what she's doing here. She knows she's lost. She knows that legally she's in the wrong, but she still wants to wait and see just in case waiting may bring something beneficial to her. In any event, I will say that when I opened the envelope and I read the response from Mr. Kevin Benson, I was pretty surprised. This was the first attorney that I felt I had any respect for. And it's not just that he didn't come off as obnoxious and throw out a bunch of lies. It was the way he presented himself, the way he wrote, the way he... And then later on when he goes to court, it's the same thing. It's a very professional individual. And I think that Kevin Benson and his demeanor is probably what the average person who hasn't had any experience with the court system expects of an attorney, and maybe even a judge. In my opinion, Mr. Benson came off more judgely than any of the judges that I had been in front of, to this day. So anyway, let's go ahead at this point and take a look at what the government has filed. Here we have the Attorney General's response to petition for writ of mandamus. I don't know if I've mentioned this before, but anytime you sue the government, typically if it's a state entity, the Attorney General is obligated to defend that entity. With like municipalities and counties, it's different. I think with municipalities, it's the city attorney, and I think with counties, it's the district attorney. But with state entities, it's the Attorney General. In any event, the attorney here representing, the attorney here who's been assigned to the case by Catherine Cortez Masto, who's the Attorney General, his name is Kevin Benson. He's the Senior Deputy Attorney General. He's been assigned the case, and he is representing the Secretary of State in this situation. It's Ross Miller. Now we have a different one. It's there's been an election or something like that. We have a different Secretary of State, but none of that matters. Just letting you guys know, this is kind of old. They have filed an answer to my petition for writ of mandamus as directed to do so by District Judge Patrick Flanagan. We are moving now into the points and authorities. He starts off with the procedural history. The first thing he points out is that the case at bar is a result of ongoing litigation by me to obtain my ex's actual address. Next assertion is that my ex applied to the Secretary of State's office for a fictitious address pursuant to the law by providing a copy of a temporary restraining order issued in October of 2008. The Secretary approved the application. Accordingly, the Secretary may not reveal the actual confidential address without a court order, and he cites the law. I challenged the Secretary's approval of my ex's application by bringing a petition for judicial review, which was denied on the merits. The Supreme Court of Nevada affirmed on the basis that there was no contested case, and therefore judicial review was not appropriate in the first place. He then asserts that I sought an original writ of mandamus from the Supreme Court of Nevada to compel the Secretary to disclose my confidential address to me. The Supreme Court found that the petition for writ of mandamus was the correct procedure, but denied the petition on the basis that the district court, rather than the Supreme Court, was in a better position to hear the factual issues. And then I followed my petition, and that's what he mentions. The Secretary correctly issued the fictitious address to my ex and has no interest in the merits of my petition. Now, he's not saying that I'm wrong. He's just saying that they're not interested in whether it issues or not. He goes into the law. The law requires the Secretary to approve the application if it's accompanied by specific evidence, and then he goes into that subsection that provides restraining orders to be one example of specific evidence. As the Supreme Court of Nevada held, the Secretary was required to grant the application based on the law and the temporary protective order provided by my ex. It appears that the sole issue in this proceeding is whether, despite the issuance of the address, I am nevertheless entitled to a court order commanding the Secretary to turn that address over to me. He cites the law, and then he cites the Supreme Court case. The Secretary has no interest in the substantive question of balancing my rights as a parent to know where my child resides versus my ex's rights under the confidential address program. And then he concludes by saying that the Secretary takes no position on this question as to whether or not I'm entitled to know where she resides, and therefore, the Secretary requests only that the judgment entered by this court be rendered in accordance with the law. This is the best possible outcome. I was hoping that he wouldn't pull a stunt and try to defend her like the white knight that Charles Wayne Howell did, was. He is instead following the law. He's following the Supreme Court precedent. He is not concerning himself with whether or not she's entitled to protection, with whether or not I'm entitled to knowing where she resides. All he is asking the court to do is to follow the law, which is exactly what I would have expected an attorney to do from the beginning, and which is exactly what I would have expected a judge to do from the beginning. So this is 100% the best possible outcome. When I read this document, I was extremely pleased. I did not need the government to take up her cause and get in my way anymore. I was sick and tired of it, and I think he probably noticed it based on the fact that I litigated all the way to the Supreme Court and got an opinion published by Justice Cherry. So to see this was very heartening, because at this point I knew that my only enemy in this case was my ex. It was not the government. He was just there to observe and to make sure that the judge followed the law, which, by the way, is the beginning and the end of protecting our child. Our child didn't need anything but the system, the attorneys, and the judge to follow the law, period. Once this starts to occur, he starts to get protection, which is a beautiful thing, which is what you would think would happen when the people who are part of the legal system comply with their own rules. Moving on. Next section here is an affirmation, which is stating to the clerk of the court that this document doesn't contain a social security number. And then we have certificate of service under Rule 5, which is indicating that this document was mailed to me and my ex's attorney. Moving into the next document, we have a notice of hearing. So I filed a notice to set earlier in the case. You would have gone over it, I think, in part 114 of the My Docket series. Anyway, I appeared, and so did the Senior Deputy Attorney General. He appeared and I appeared. Why are they saying that I didn't appear? I did appear. That's interesting. I don't think this is true. So he's saying that I didn't appear at the setting, but it's not true. I definitely appeared. In any event, I appeared and set this hearing, and if I didn't appear, I showed up at the hearing, so that's not a big deal. It isn't a good idea to not appear at a setting, because a hearing could get set on a date that you're not available, like a work date or something like that. But whatever. I mean, if he's mistaken or not doesn't concern me. I don't care, because this is not something that became an issue in the case. It's just a little odd. The hearing was scheduled on August 19th at 11:15 a.m. And that appears to be that. This is another affirmation. Here we have a certificate of service indicating that he served me on July 25th with a copy of the notice of hearing. Next is, oh, by the way, guys, I have a video on this. Please watch the video notice of, no, I don't know if I do now. I might have a video on notice of hearing. If I do, take a look, and just in case, watch that video. It tells you what the purpose is behind the notice of hearing. If I didn't do that, please mention it down in the comments below, and I'll think about putting together a video on notice of hearings. It'll go into the legal nuts and bolts category. Next, we have my notice of hearing. This is one of the reasons why I strongly believe I probably was at the hearing, because I filed a notice of hearing. Okay, so my file here, I indicate to the court that an evidentiary hearing was scheduled on August 19th, 2013 at 11:15 a.m. And I would assume that I appeared at the notice to set. This isn't something that I would miss. I guess there may have been a mistake or an accident, but I highly doubt it. 99% sure I did show up at the setting and that I did participate, and that's probably why I did file the notice of hearing right after. Same thing that the Attorney General filed. It's just another notice of hearing, and this is just me trying to make sure that everyone has noticed. By the way, guys, my ex didn't appear, and I don't know if this is mentioned now or later, because she told me, and I can't remember if it was by email or over the phone, that, oh, we're not going to really go in and participate in this hearing. We're going to let the Secretary of State defend us. And I remember saying, I don't think that you guys are going to get that, because they filed a response indicating that they weren't going to defend you. And then her attorney didn't even respond. So it's like, okay. And then we go to court, and the hearing is exactly what it was, which is the judge goes, Mr. Falcone, what do you want? And I'm like, turn over the address. And then he goes, what do you think about that, Mr. Benson? And he's like, we don't care. Just follow the law. And the judge is like, oh, okay. And then he orders, the address turned over. So at this point in time, I'm going to go ahead and move on to the aftermath. Going into the aftermath, I filed just one document. It was a free filing, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex-attorney has not participated in the proceedings, so she incurred $0 in attorney fees. The government filed two documents, but those were, I'm pretty sure, yeah, those should have been free filings. So the government incurred $0 in costs. The government would have spent, I imagine, I was going to say 30 minutes because it was such a short response, but I think he would have at this point in time taken the opportunity to review the opinion, review the law. He wouldn't just, this isn't really a copy paste document because it's based on new precedent. So I think that it's probably closer to 45 minutes in the government's time to prepare that short but thorough petition, response to my petition. So 45 minutes there. I think to review my notice of hearing, 0, because he filed his own notice of hearing, which I think would have taken maybe 15 minutes to prepare if you combine the time to prepare it, which isn't very much, with the actual time to appear at the setting. Appearing at the setting is a 5 or 10 minute thing. So we've got a total of an hour in attorney fees for the government, which at the rate of $250 an hour comes to $250 in attorney fees for the government. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.